appreciate your comments and your perspective. And what I would say here is you have a good nurse and a good case manager. The problem with the Texas law is not the good nurses and the good case managers. The problem is with the case managers who want to replace, well, I'll give you a couple examples. So you're not the problem. And there are a lot of good caseworkers, there are a lot of good nurses and doctors and administrators out there. The problem is those who have other things in mind. Under the existing Texas state law, I want to point out one thing that is an unintended consequence of tort reform. I want you to think about this. And before I do this, I won't be like a politician. I will answer your question. Under the law, under the Texas 1999 Advance Directives Act, there is no reporting mechanism. So the number of cases where a hospital committee has overridden the desire or the wishes for future care of a patient or family are not reported. The reason they are not reported is because lobbying from the Medical Association, the Texas Medical Association, they do not want the numbers reported. Now, the reason I know that is because I was there when the lobbying occurred in the legislature. So there's no reporting, so there's no way to know. The second problem with this is if you find yourself down the road where you disagree with a decision of a death penalty, the legislation gives one tiny, tiny little window. Now realize at a time when you should be caring for your family, you're given 48 hours to prepare for the death penalty. If the death panel ratifies this decision to end care, you're given 10 days to find treatment or a new facility to accept your loved one. And if you can't do it, they can withhold food, water, and care. That sounds like a death panel to me. Now, at a time when you should be caring for your family. Now, I'll tell you, if you're ever in this situation, I hope you're at one of your 13 facilities in Houston. Because if you're at a Memorial Hermann facility, forget it. Okay? Now, two things I want you to think about the way I see an impact and an unintended consequence of how these death panels in Texas work out. Under the tort reform that was passed, and I'll say as an attorney, I found there's a lot of merit to some of the tort reform that was passed. But do you realize that I'm also a conservative that believes in economic incentives? There's an incentive with the death panel legislation now that if there's medical malpractice that causes a brain injury or causes someone to need a lifetime of care, there's an economic incentive for the death panel to meet and stop care. The reason is you can cap your award at $250,000. So you have a medical incentive under Texas law if you work the tort reform in with the death panel legislation. Now, I'm very happy anytime one of these comes up, whether someone calls me or whether Texas Right to Life calls to step in. And I do this as a part of my practice for free. I don't charge people this because I believe in helping them in this fashion. The problem with the legislation is this. I can go, but there's only this much that I can do. The only way under our death panel statute in Texas that we can challenge this or get any of our fine judges to step in is if I can go and through evidence convince a judge that with some additional time that we can find a different facility to accept them. Now, this is all during a 10-day period. And I think it's just an inhumane system. When you should be caring for your loved one in the hospital, you have to go fight the hospital in these instances where it's done. I think it's a shocking thing, and it's something that needs to be overturned. The judicial review under this statute is really a joke. There have been, I think, 3 reported cases since 1999 in the books that went to the appellate court where there were written opinions. And the reason is 10 days, you can't do it. It's very rare to be able to get an injunction in these cases.